afternoon, everyone. Welcome back to many of you. For those of you joining us for the first time, I'm Maggie Mahan, the Assistant Director for Community Engagement with the State Historical Society of Missouri. Thank you so much for joining us today. As the Associate Director of the Cape Girardeau Research Center, Bill Eddleman presents the 8th installment in his Beginning Genealogy Workshop Series. Today's program will focus on using probate records. If you need to catch up on previous installments of this series or would like to rewatch any of the segments, you can view them on demand on the State Historical Society of Missouri's website at shsmo.org. All events in our virtual programming series are made possible thanks to the generous support of the State Historical Society of Missouri's members and donors. Visit our website to learn more and see how you can add or renew your support. Thank you again for joining us. And now I will turn things over to Bill. Thanks for being here, Bill.
Thank you, Maggie. I'd like to welcome everyone back if you've viewed one of these presentations before. And as Maggie said, I'd like to welcome anyone who has not seen the earlier presentations. And I hope you go back and look at them so you get a more complete picture of genealogical research. The type of records we're going to talk about today are just invaluable if they exist for your ancestor, and that's probate records. And we're going to talk about the different types of probate records and why they're useful and how to use them and some hints on how to use them. First of all, a little bit of a definition and then the reason why we do probate. Probate is the legal process of administering a person's estate after their death. And it's termed testate if the person had a will, or intestate if they did not have a will. There are different types of wills. We'll talk about those as well. It's done to provide an orderly and fair process to transfer property to the heirs of the deceased. Even though it is ostensibly fair, there's still oftentimes lawsuits that happen as a result of probate. We'll talk about some that are actually friendly lawsuits and not so much others that aren't friendly, but if you're in a state that had a chancery court system, that's where you find the unfair ones being resolved. A will provides instructions on how this should be done. So it's very explicit and spelled out by the deceased. Lack of a will means that the process falls back to the laws of the state to guide distribution of property to heirs. So what are you going to find in probate record? First of all, with caution, you can infer a death date. Oftentimes, probate happens very quickly after a person's death. The quicker, the better, because otherwise you open things up for more legal action later. You can get relationships. Oftentimes, you'll find explicit mentioning of how people are related to the deceased in a probate procedure. Names of associates of the deceased who were involved in different steps of probate, including appraisers, creditors and debtors, bondsmen, those who provided money to back up bonds related to probate, the administrators, and buyers at sales. All of these were oftentimes friends, associates, or neighbors, the so-called fan club. An indication of occupation and economic status. I actually did this with an ancestor of mine for the Southern Museum of Historic Decorative Arts. They were asking me if this ancestor had perhaps been a furniture maker. If I looked at his probate, I found that among his property was a lot of fine carpentry tools. So yes, indeed, he was a furniture maker. Sometimes death dates of other family members, if they're there at the initiation of probate and then they drop out later, usually that's a pretty strong indication that they actually passed away. And you at least get a date range. Sometimes medical information. Some of the most entertaining things I found in probates were doctor's bills, and you get a kind of an idea of either the competence of the doctor or the medicine of the time, or else what was actually the cause of death of your ancestor. Oftentimes, original signatures, which you can use to match up with other documents, original signatures. There are some limitations, though. Probate may not have occurred. That's the biggest limitation, and we'll talk about why later. There is oftentimes no requirement that every child, or sometimes even the widow, may be named. This is particularly true with testate inheritance, with a will. Places of residence may not be mentioned. We don't know where the person lived. We usually infer they lived in the county or jurisdiction where the probate happened, but not always. Maiden names are usually not given for the wife in particular. The exact date of death is oftentimes lacking. You get a range generally, or you get an approximate date. It may be difficult to actually locate probate records if the person moved recently. The key question is, did they initiate probate where they were living at the time of death after a recent move, or is probate back in their original county or jurisdiction of residence? Indices oftentimes are just by the testator's name or the deceased name. They're not giving all the names in a probate procedure, which oftentimes is the most valuable part. Also, beware of myths. Myths grow up around a lot of these records, and one of the biggest myths I've seen about probate is wills. There's some myth out there that all heirs had to be left something in a will, and that is not true. Usually if somebody was left, say, a token amount like $1, it was not to cover something. It was because they'd probably already been provided for by the deceased at some earlier time. This is particularly true of older children. You really need to know the law of the state or jurisdiction where the person died, because the law regulated what happened in the state for probate. Mostly state laws, sometimes other jurisdictions. This helps explain documents in the probate files that may be very perplexing otherwise, and also what events and the course of events that happened during probate. You also have to keep in mind laws changed. You want the law that was in force at the time of probate of the deceased estate. Okay, first of all, we're going to direct a few comments toward testate inheritance. You'll find that some ancestors, if they had a will, that may be it for probate. You find nothing else. For other ancestors, there may be a full probate file, even though there was a will. It's usually because they had a lot of property. So an attested will is prepared in writing and signed by witnesses. That's the most common. Usually the deceased knew they were not going to survive long, or perhaps they were just planning for the future and making sure all loose ends were tied up in that eventuality. You'll see oftentimes years separating the will from the actual death of the person. A holographic will was written by the testator and dated, but there were no witnesses. If there's any other person's handwriting on the will, it voids a holographic will. It has to only be the testator, and it has to be dated. I found those to be relatively rare. Non-cupative wills are oral dictated wills, usually from the deathbed to witnesses. One of the witnesses typically wrote it down, and then if the person was not too ill, they would sign the will sometimes, and then all the witnesses signed the will. I've seen these on a number of occasions. Typically when someone was taken ill, or in the Civil War, if they were severely wounded, there might be a non-cupative will. What information do you get in wills? Well, oftentimes heirs, but keep in mind that does not have to be exhaustive. There are all sorts of examples of people who had heirs who are not mentioned in wills. Oftentimes, their names and places of residence. So my daughter, Mary, wife of John Smith, who lives in such and such county, Ohio. If you're lucky. Sometimes they'll just mention the name and you don't know really where they were. Names of enslaved people may be in wills. And again, typically just the given name of the slave. Death date or approximate death date. If the will was presented for probate and it's right after it was written, you know that you've got an approximate death date. Approximate ages of minor children. Previous residences, and by that, minor children approximate ages, if they were under 21, is typically what I'm meaning there. Previous residences, I'm of this county, but I'm formerly of this county, is sometimes mentioned. Occupation. I, John Jones, farmer of this township in any state, U.S. Economic status. If they had a whole lot of property, there was usually a lengthy will. If they had very little property, typically a short will, although short wills can happen with lots of property. I leave it all to my wife, for example. Economic status can vary. Original signatures, very valuable, but keep in mind, if you're looking at a will in a will book, they're not original signatures. That's a copy of the original will. A lot of times what I find where there are probate files for someone that had testate inheritance, the original will is in the probate file. The will book has a copy. The steps to probate a will. First of all, the will is written. The testator usually professes to be of sound mind or age and not under undue influence. The will is then proved in court after it's presented to the court, which usually means the person is dead, and then is certified as valid by witnesses typically. The court issues letters testamentary to the executor of the will or executors. A lot of times it's a spouse. It may be a spouse and a child, a spouse and a friend, or a friend, varies. Notice to creditors and debtors, which is usually published in a newspaper or by public notice. And then the probate process usually proceeds just as it would for someone who died intestate. So here's the general form of a will. It typically begins with the sort of language that I refer to as boilerplate, which is fill in the blank type language. In the name of God, amen. I, John Dunham of Williamson County and state of Tennessee, being in sound sense and memory, etc. And then oftentimes, if it's a very well organized will, they have points. First, appoint the executors. Second, empowers them to sell certain lands and so forth. And there may be all sorts of other points. I've seen as many as 20 some odd points in these wills. Usually there's a mention of heirs. And here we have the benefit of all my children. I would say this is a reasonable bet that in this case, all the children are mentioned because it is so stated and equally. So interesting thing, why is this recorded in Cape Girardeau County and the John Dunham died in Williamson County, Tennessee? And as I found through research, he actually has a will recorded, the same will, in Williamson County. Well, the answer in this case is his widow moved to Cape Girardeau County with property, specifically enslaved people. And I would imagine this was a way of making sure title was clear to those enslaved people. And then on and on and on, but I will point out something here. This slave down here, Edmund, I found this will when I was researching for a descendant of Edmund, her ancestry. And this is very rare. I actually got him back to age 7 in 1817. So very rare event for an enslaved ancestor to be traceable that far back. So again, you're looking at wills of the enslaver in order to research enslaved people as well. There may be codicils, which are additions to the will after the original writing, not in this case. And then there are signatures of witnesses, and test or attest means that the people who are witnessing would be willing to testify in court that they saw the will written. And in this case, there were 4 witnesses. And then it also states, because this was from the will book, that it was produced in open court and was proved, which means it was officially accepted by the court. And then there's, if it's a will book, there's some indication that it's a true copy, and it's usually signed by the clerk. And this is from the Cape Girardeau County will book, proved as the law directs. So it was proved in Williamson County, and it's also recorded to that effect in Girardeau County, so we know it's an official will. And letters testamentary were issued to Polly and William Dunham, the widow and the son. All right, some limitations of wills. Once again, not all the heirs may be mentioned. I think I've talked a lot about that already. May not provide for all the property, in which case, if not all the property is provided for, probate has to happen a little bit more officially than it would otherwise in order to distribute that property. The date of writing and death date are often separated by many years. I've seen as many as 30 between the writing of the will and the death of the individual. Original copies may be missing. And remember, the will books are copies. Because they're copies, always be a little cautious about what you're reading in there. If it doesn't match up with other records, it may have been miscopied. Clerks may swear that they copied it well, but we're human and they're human, so they may not have. All right, so what about probate? Probate goes through a series of steps, and I'm going to talk about a typical probate. The specifics may vary with the jurisdiction. The individual I'm going to follow through is a man named Matthias DeVault, who died in 1820 in Cape Girardeau County, Missouri. I haven't documented this yet, but he's probably about a 6th greats uncle of mine. I'm not sure yet. DeVault moved from Lincoln County, North Carolina to Wilson County, Tennessee in about 1803, then to Cape Girardeau County by 1817. His probate file, or loose, you'll see probate files called estate files, loose papers, estate papers, a variety of different things, all that mean the same thing. It's all the papers that resulted from the probate process. So in this case, his file has a pretty typical set of probate documents, which is wonderful, but it's not always going to happen. Documents were lost, documents were never generated in the first place. If you research in Virginia, forget this, there were no probate bundles. Everything was handed to the family when the estate was closed out. So you only have court records to look at today, or lawsuits. And Peter Smith and Andrew DeVault petitioned the Cape Girardeau County Court, which served the probate function at the time in 1820. It was Missouri territory, not the state of Missouri yet. And so on the 16th of October, 1820, sometime just before that, Matthias DeVault passed away. So the first step is you're going to the court and saying, the person's dead. We need to start the process an administrator of the estate needs to be appointed. And you notice this time it's not an executor like it is with a will, because there's nothing to execute. It's an administrator to make sure the process is followed and the property is distributed fairly and equitably. So the administrators were appointed, and it was Peter Smith and Andrew DeVault. And they had to post a bond. Why is that? Well, otherwise they could abscond with the whole estate and the heirs lose it all. Typically, if they post a bond, if all else fails, they have to come up with the money. And so the bond is typically an amount at least equal to the value of the estate. It may be more, it shouldn't be less. Often required several bondsmen in order to get up to the amount of the estate. Not everybody had that sort of ready cash or goods. In this case, 2 administrators and John Smith and Daniel DeVault served as bondsmen in order to get the amount of the bond posted. So the date of the letters of administration were the 16th of October, also the same date as the posting of the bond. So Matthias DeVault, again, probably died right before this. Almost immediately after the administrators are appointed, they were supposed to post a notice to creditors and debtors. This individual has died. If you owe the estate or are owed by the estate, step forward now. Otherwise, you may be left in the cold. So that notice was usually published in a newspaper if there was one, or it may be posted in public places. Okay, next is the inventory. And the inventory was an accounting of everything that was in the estate. And people were typically appointed to inventory and appraise at the same time, although they're paid as appraisers. So appraisal means we've got the items in the inventory. The appraisers have to set an approximate dollar value on each item. And in this case, John Lawrence, George Rhodes, and Henry Baker were appointed appraisers. They were also paid for their services, as we'll see later. And here's part of the appraisal. Matthias DeVault had quite a large estate for a farmer of the time, and so lots of things to appraise and inventory. By the way, the inventory listing would look very similar to this, except no values assigned. Then very quickly after that, the widow's share of the estate had to be allowed. That is, set aside so it would not be sold. And a lot of times the law specified what should go in the widow's allowance, and then she might claim some additional things which would be covered out of her share of the money that is generated by the sale. She may want additional things. So here, Missouri law is very specifically, during territorial times, laying out what the widow should get. And here is the listing for the widow of Matthias DeVault. If there was no widow, if the individual who died was a widower, no widow's allowance needed. Next, there would be a sale. And again, typically someone was hired to be the auctioneer or crier of the sale. And the neat thing about sales, I love to look at sale bills and sale lists because it lists who bought everything. Why are these individuals the ones that bought? They may be a relative, or they may be a neighbor, or they may be someone else who's close to the deceased in some way. And so we may need to fall back later and do research on some of those individuals in order to figure out the person we're interested in. So in this case, there were a number of defaults, children of Matthias, sons of Matthias, a couple of sons-in-law of his, and then other people who were undoubtedly neighbors who were buying at the estate sale. The administrator administrators had to keep records because they had to report to the court periodically, at least annually. So an annual settlement was essential. So here's one statement that was in the probate file for charges and credits that they had assembled since the last report to the court. Otherwise, they don't report annually. They're going to be either removed as administrator by the court or fined in some way, shape, or form. Then, when everything was cleared, and we're going to talk about some of the other things generated before the estate was totally cleared, there would be a final settlement. So there had to be a notice for final settlement because creditors, heirs or legatees, and others had to come forward by the final settlement or they would forfeit any right to anything. So there was a notice, come forward or speak now or forever hold your peace. If it's a complete file, you will also find receipts from all the heirs as to what they received during the distribution of the estate. Here's 3 of those: William DeVault, Wiley DeVault, and David DeVault, all sons of Matthias DeVault, and how much they received, which should be a relatively equal amount. Then there are also receipts that relate to expenses by the administrators or payments of debts that the deceased had. You had to document that things had been paid, so there are releases and receipts. This is where you oftentimes, even though this may not have involved your ancestor, you may find your ancestor's signature in here because the person owed them money or they owed the person money. There may be all sorts of other things in probate files. Guardianships. Any child under the age of 21, if they lost at least one parent, had to have a guardian appointed by the court. And this is another way to check on approximate ages of some of the children. When they were released from their guardian, that means they turned 21. They were signing for themselves typically. Dower petition or assignment. The widow was entitled to 1/3 of all the property of the deceased during her lifetime. After her death, that 1/3 went back to the estate and was usually distributed amongst the surviving heirs. Or the widow could assign her dower right to someone else or just forfeit it. She had to do it in writing. There may be all sorts of documents related to court cases. People sued each other over debts related to the estate. There may have been unfair treatment alleged, in which case there would be a lawsuit. Other petitions, I don't think the administrator is doing a good job and I'm one of the children, so therefore I'm petitioning the court to forfeit or to negate this administrator and appoint a new one. Be one example. Powers of attorney. I appoint this person to be my attorney to collect the money due me as a child of the deceased. So you dispatch someone that could come to the area and they'd be your attorney for acting in your behalf. So lots of other things, all sorts of other documents can appear. Occasionally, as I mentioned, the administrator either died or was not doing their job, unable to fulfill their responsibilities, in which case they were released as an administrator and a new administrator was appointed. The term for this is administrator de bonus non. So if you see that term, it means they're not the original administrator. These also had to be appointed by the court. They also had to post a bond. If the executor died or was unable to fulfill their responsibilities, and again, this is with a will because it's executor, they would appoint an administrator with the will annexed, not an executor. So if you see that term, typically when estates took a long time to settle, the executor might have passed away, in which case they needed to appoint an administrator with the will annexed. Occasionally, you'll have situations where, say, there's one piece of real estate belonged to the deceased, and he has 10 children. There is no way, if it's something like a 40-acre parcel, that it's worthwhile to divide that into 10 pieces of equal value. Sometimes it's impossible to get equal value. So in that case, to force sale of the property, a lot of times the heirs would sue each other in order to force sale. That was called a petition to partition. So some of the heirs acted as plaintiffs and others as defendants. Now, I've seen people see this and say, oh, they hated each other, they were suing each other. Don't assume that was done out of animosity. It was just a device to settle property where it couldn't have been done fairly otherwise. Money's a lot easier to equally divide. All of the heirs were typically named in a petition to partition. And these are going to be in court records. They're not going to be in the probate file. So even minors would be named with their guardian acting on their behalf. This was usually done very late in the probate process. So some of the heirs may have died. They may have moved away and nobody knows where they are. So you'll see sometimes the unknown heirs of Samuel Smith. It means he moved away, they don't know where he went, or he may have died somewhere and we don't know that. So their heirs were part of the suit, but there's no way to find them. No internet back in those days. Here is probably one of the most thorough, valuable ones I've ever run across, where by the time they tried to settle the estate in 1841, the deceased died in 1830. So it was 11 years later. Some of the daughters had married since then and then died and had children. So they had to come in on the petition to partition. And in this case, it was Catherine Barks died and had all of these children. And they came in on the petition to partition, which is great because a lot of times you won't find out about those children otherwise. Sometimes even children have married and it'll mention their husbands. So if you find a petition to partition in certain circumstances, it's really, really valuable. A bit about guardianships. Minor heirs who were under age 16 or 21, depending on the time and place. Missouri, it's pretty much always been 21. At times in some of the original 13 colonies, it was 16. Doesn't mean both parents died if they're called orphans. It means one parent died, at least, usually the father, and there may be a guardianship and they may be referred to as orphans. And oddly enough, their guardian may be their mother. Because remember, women had a lot fewer rights early in the Republic. These were either appointed by the court, or if the minor was above a certain specified age in the law, they could choose their own guardian. The guardian signed documents and had to account to the court for their guardianship. So they were holding money that belonged to an estate, and so they had to account for that. Probate packets may have guardian records. There may be separate guardianship records and packets. So ask about that or try to determine that for the area where you're researching. Guardianships were also appointed for incompetent adults who were ruled that way by the court, and it's the same process as probate. Why is that? Because the county, at least in Missouri, the county had to pay for people who were committed to a state hospital if they were deemed incompetent. So if the incompetent individual had property, they wanted to recover their costs. Here is an example of one for an individual who actually, this is a case where the individual pretty sure was suffering from post-traumatic stress disorder from Civil War service and was committed to the state hospital twice. Both times he had probate files, and his brother was appointed his guardian, and some other individuals as well. And so it's just like a probate. Even though he wasn't dead, he was incompetent. All right. Sometimes you'll find an ancestor, they died in the prime of life, say in their 30s or 40s. And you think, wow, they had property, they had land. Surely there's a probate. Nope, not always. First of all, check the state statute for the time period if you can't find a probate. There may be situations where it wasn't required. They may have had no property, in which case nothing to probate. Why bother? Property may be in another county, so their probate may have been done elsewhere. So search alternate possible sites. If the deeds completely agreed on distributing property, especially real property, there may be no probate because there was perfect agreement and there just may be deeds. There was one individual I researched for somebody and I thought, great, it's got a probate. He died when he was relatively young, no such luck. But if you look in the deed books, there were a series of deeds where all the heirs were deeding his property to one of these sons-in-law who eventually ended up with all the property. They apparently agreed, oh, this is the way we're going to do it. It's equitable. We don't want to go through probate. Silent transfer is usually done from father to child, from them to their child, and nothing's ever recorded. The worst I've ever heard about was 203 years worth of silent transfer before a deed got recorded and no probate. So you never know what odd things can happen. The individual may have intentionally avoided probate. Illegal, but they may have done it. It may also be delayed until a spouse died or when the property needed to be transferred. Then they initiated probate. Most of these are rarer events, but they do happen. Probably the most common is no property because the person was quite old when they died. They'd already transferred their property to children through deed or through just gift, and so they had nothing to administer at their death. That's the commonest situation, old age and no property. You may also have the wrong approximate date. The person actually lived another 10 years past what you think they lived, in which case their probate would be a different date. Check court records for a petition to partition if you can't find a probate file. It does happen, so you'd have to go to court records. And the court that was handling probate could be circuit court, could be county court, could be a separate probate court. It depends on the jurisdiction and the time period. Finding documents. Well, first of all, wills. Where do you find wills? Well, you can check online indices. If you're really lucky, the wills are on Family Search. They were microfilmed by the Church of Jesus Christ of Latter-day Saints, and they're available as digital files. Again, you have to have a free account in order to search those and look at them. They may be an ancestry. In some jurisdictions, they have been not only digitized, but also are on Ancestry. Sometimes on local society pages when they're nowhere else. So check the local genealogical or historical society, internet pages, web pages. If accessible, check library resources. If I can, and I'm at a big library, my first stab is looking at books if somebody's done abstracts of the will records, because I don't trust them totally because of transcription errors, but they're a good leg up on getting to the original records. Check local resources. So societies and those individuals in societies that know the records backward, forward, up and down, and sideways. Courthouses and archives. The probate documents may actually be elsewhere. Originals may be in a probate packet or filed separately. So again, the wills may be in the probate packet, may be filed separately. Copies in will books, probate books, or if the land was involved, in deed books. Those are copies, they're not the originals, so always keep that in mind. I've seen lots of times whole wills transcribed into deed books as well as in the will book because they involved real estate. As far as probate documents, check the same online indices that you would for wills. If accessible, check library resources. Contact local people knowledgeable about local research. This happens, by the way, far too infrequently. So many people have fallen in love with trying to find things on Facebook that they don't realize that a lot of these real experts are older and may not be on Facebook. So you may actually have to check locally. Probate books may be digitized and online. They may be in the courthouse or in an annex or archives. The packets are the ones that really make a journey oftentimes. They may be in the courthouse, great, where they were originally. They may be in a records annex. They take up a lot of space, so oftentimes they get them out of the courthouse. They may be in a local archives if the county doesn't have a records annex. They may be in the state archives for some states. Or in some states, like I mentioned, Virginia, they may not exist at all. There were no probate packets. Check court records for lawsuits connected with disputes related to settling an estate or for petitions to partition. Just running through a couple of examples. Here's one where I'm going to use family search. Again, you log in with your free account, search the catalog, and usually by place. So here, by the way, if I just typed in Cape Girardeau, below would pop up this whole string. You need the whole string, so click on it and it will go into the search bar and then click search. And it will give you all the records for Cape Girardeau County, whatever county you were searching. And then you go down to probate records. By the way, there's probate records indices usually. That's usually a published book, which is going to be in the library out in Salt Lake City, but it's not going to help you at home. So just click on probate records. And here I'm most interested in the probate index because I'm actually going to look up Matthias DeVault and see, where his records are. And it tells me that it's in Will Records A. And there in the probate records, I've got Matthias DeVault, estate of. It tells me where the different types of records are duplicated. What I showed you before was from the probate packet. Nobody indexed those, at least not very often, because they're too big. But it tells you where things were recorded in the probate minutes. Let's look at an example, and this one's going to be Samuel M. Phillips Jr. from Alexander County, Illinois. This is from Ancestry. Some Missouri records are in Ancestry probate records, but not an astounding number. So you're going to click on the card catalog, which is where you get at specific records that a general search will not bring up. If all you're using is the general search in Ancestry, you're missing a large boat because the card catalog is really where you get at the specifics. So I'm going to click on card catalog and search for US probate. And it gives me a number of states. And if I scroll down enough, I'll hit Illinois. And I click on that. And then I get a search screen for Illinois probate records. Again, if I were to just search in the general search, I wouldn't find this. So I'm going to look for Samuel Phillips. And I get a bunch of hits. And the guy I'm interested in was, Alexander County, Illinois. Click on View Record. And there's a bunch of documents. I know he had a large estate. And then view the originals. And I'm going to get one of those film strips down at the bottom where I can move around and look at different documents. In this case, it's the probate packet. Boy, am I lucky. I've researched in Alexander County, Illinois in the old records. I'd just as soon not go there again. It's in an unheated, unair-conditioned brick building in back of the current courthouse. And the day I was there, it was about 85 degrees, but in the building, it was more like 100. All right. A general research strategy for probate. First of all, learn the law. It is going to explain a lot when you start scratching your head about why certain records are there and why other records may not be. Determine which court handled probate. If it was handled by the county court and you're looking in the circuit court records, you're not going to have any luck because wrong jurisdiction. Find the probate index if it existed. If not, you're going to have to search in the probate minutes. Now, there may be an overall probate index or not, but sometimes if there isn't one, there may be an index in each probate book, in each minute book. And if you're really unlucky, there's none of that. Order books in Virginia, for example, is where you find a lot of this. And there's no index for a lot of counties. You just have to go page by page. Then find the indexed records in the appropriate books. And you can go through and abstract or transcribe those. And then locate the probate packet or find out if they exist. And if they don't exist, you're out of luck. You've got what was in the appropriate books. But if they do exist, you need to find them and find out where they were and find out whether you can access it or whether you have to tell somebody, I need this, please have this ready when I come to research. It depends. You got to work with people on the ground locally a lot of times. You can't just walk in and from the cold and research these things. If the specific packet is missing, back up to the minute books and reconstruct what you can. A lot of times people feel that, well, I'm a descendant of this person and I really need to protect their records. And back before security got tighter, they would walk out of the courthouse with their ancestor's probate packet. In some cases, those might have been my ancestor, and I'd like to find that person and strangle them. But it happened. If your ancestor had no probate, check for the probate of their relatives, children, parents, grandparents. It may mention something like this land was inherited from his father and then the father's name. Aunts and uncles, any relatives, that's where you'd go first to try to find information if your ancestor had no probate. But if that doesn't pan out, you're going to have to go to associates. It may mention your ancestor as an adjoining landowner, for example, and when. Best practice, if you can, do this. Transcribe every document in a probate file. I have overlooked so many things by just skimming through a probate file. You're going to miss minute details that may make everything fall into place. And here's a great example of that. This little unassuming document is what got my sister into the DAR. And if I ever choose to join the SAR, will get me in the SAR. I needed to make a connection between Jane Smith, the wife of Peter Smith, and Jacob Rhine, ostensibly her grandfather. And I was trying to do it one generation at a time, the way you're supposed to. I didn't get any help from her father's probate, Martin Rhine. Jane Smith had been Jane Rhine. Her mother was also Jane Rhine. She had a probate file as well. And when I started transcribing documents out of her file, I found this one. Estate of Jane Rhine to Peter Smith, et cetera, P. Smith, et cetera, to a claim of legacy to the amount of $28.79 and a half, will to my wife Jane by her grandfather Jacob Rhine. I made the connection across two generations in this case, skipping Martin Rhine, and made the connection to the son of the patriot that I needed to connect to. So, and this is just this little bitty receipt in this huge probate file. So in conclusion, I'd like to wish you a productive journey in probate records. So good luck with working with probate.
Thank you so much, and we'll look forward to joining you next time. Bye-bye.